Yes, Your Honor, thank you. We move for a mistrial based on the testimony this morning. Your Honor, there are a couple of different reasons, but what's clear is that the court set guardrails for this testimony, and the guardrails by this witness, answering questions from the government, were just thrown to the side, and there is no way to unring the bell, in our view, and that the testimony that came in was so unduly and inappropriately prejudicial to President Trump, and the actual charges that are at issue in this case, that there is no remedy that we can fashion, or we believe the court can fashion to unring this bell. I mean, the testimony, Your Honor, about the alleged incident back in 2006, a lot of the testimony that this witness talked about today is way different than the story that she was peddling in 2016, Your Honor, which is, from my understanding of what the ADA said this morning, the only reason why this evidence is even admissible, right, is to talk about the information that was supposedly kept from the voters in 2016. There was testimony today about being blacked out about not wearing a condom, which was after there was testimony from her employer that you had to wear a condom, that there was always a condom worn, the height of the two individuals. The fact that, the things like the spacing in the room, the fact that there is a bodyguard outside the room, the power dynamics. She testified the question was, do you want out of the trailer park? And all of this has nothing to do with this case. And it's extraordinarily prejudicial, and it's something that is the only reason why the government asked those questions, aside from pure embarrassment, is to inflame this jury to not look at the evidence that matters, but to just hear from this witness. And on top of that, Your Honor, even after the incident, there was testimony about a second alleged sexual advance sometime later on, totally irrelevant to this case. And there's no reason that should have been elicited, Your Honor. Again, we don't even know that that's coming, because we don't get notes of what this witness has said in prep. The last one we got was from last year, Your Honor. She testified that there was communications with President Trump afterwards, and that she thought something bad was going to happen, and that she was worried about not being safe. She then repeatedly testified about purported alleged meetings with President Trump, and with every single one she qualified that it was in an open place, in a public place. What's the jury to do with that? And for many of those you sustained objections to, Judge, and that is true, but it was said repeatedly, and the jury hears it. And I'm sure that the transcript will say, objection sustained, by Your Honor, but it's still extraordinarily prejudicial to insert safety and safety concerns into a trial about business records. And, I know Your Honor knows this, but this is exactly what President Trump was, what we raised with the court, seeking an adjournment based upon Ms. Daniels' changed testimony. For years, including up to 2016, which is when she was peddling this story, she talked about a consensual encounter with President Trump that she was trying to sell. That's what Mr. Davidson talked about. That's purportedly what Mr. Cohen was told, and that's not the story that we heard today. We heard a completely different story, and the reason why that matters is because, of course, we are going to cross-examine her on the fact that her story has changed. And I'm sure the government will then say, we've opened the door, and then they can then go ahead and ask even more questions about what she wants to say about what happened in 2006. But it's so prejudicial in a case about an NDA, and whether there were false records placed on the Trump Organization's books in 2017. And, I think Your Honor knew that this was an issue by setting up guardrails along the way in this morning, but now we've heard it, and it is an issue, and it's not how can you unring the bell. And we are going to cross-examine her shortly, presumably, and talk about and then elicit the fact that she denied twice. There were articles that said that she denied it, that she denied this took place, but that's not really the issue. I mean, that's going to be the cross. The issue is she has testified today about consent, about danger. That's not the point of this case. That's not the point of her testimony, and that's not what she was peddling. Not what she was peddling. That's not the story that she was selling in 2016, and now we're here. I mean, the least of which is the fact that just over lunch, people are already reporting, everybody is reporting that she's suggesting consent. Again, that's a new fact, and it's extraordinarily prejudicial. And the mere fact that she says there was consent after saying she blacked out, doesn't remember anything. They only had water, but she doesn't remember anything. This is the kind of testimony that makes it impossible to come back from. I mean, not even talking about the fact that we are talking about somebody who is going to go out and campaign this afternoon, and how unfair it is in that environment as well. But the government must have known this was coming out, and it's just, we sit here listening to it, and we objected to it the best that we could. But, this has nothing to do with the reason why we're here, Your Honor. And even the limited fact that she signed the NDA, the limited fact that she was selling this story over the years, including at the time of the election, that's not what we heard today. That's not how the evidence came in from this witness. Of course, Your Honor cut her off several times, but there was so much, and we haven't looked at the transcript to give all of the examples, and we are happy to do so if that's helpful. But how can we come back from this in a way that's fair to President Trump, and in a way to make sure that this process stays exactly where it should be, which is about whether there were false records on the Trump Organization's books and put on in 2017? So, we believe, regrettably, that there should be a mistrial, and that to the extent that there is another trial, that this witness is either excluded or that her testimony is extremely limited to the guardrails, frankly, that Your Honor set this morning.
Thank you, Mr. Blanche. People?
Yes, thank you, Your Honor. Again, I would just note this was fully briefed by the defense in their motions in limine, and Your Honor did not put any guardrails on her testimony. Recognizing, of course, that this completes her account. Her account completes the narrative of the events that precipitated the falsification of business records. And this story, Your Honor, her account is highly probative of the defendant's intent, his intent and his motive in paying this off, and making sure that the American public did not hear this before the election. It is precisely what the defendant did not want to become public. I will say, without getting into too many details, that Mr. Blanche's recitation of the fact that this is entirely new is not true. I will say that, and I'm sure that he knows this, that the account and things like the fact that a condom was not used has been out there for a very, very long time. This is not new. This is not a new account. Now, there were certain details that I told Your Honor that she remembered after a movie in 2019, and I was going to elicit that. You asked me not to, and I did not. But the other thing is, Judge, they opened the door to this. So the 2011 threat to her was opened on not only in their opening when they talked about legal fees and that she was changing, coming up with this story because she's an opportunist, out to make money and that she owes Mr. Trump legal fees. So they opened the door. That's the subject of the defamation case. Second, they specifically put in an exhibit which was admitted in evidence through Keith Davidson's testimony, where they referenced this threat in 2011, saying that it was not true. And so it was incumbent upon us to bring out those details in her direct, again, to rehabilitate credibility where they attacked it both during Keith Davidson's testimony and on opening. So, Your Honor, we were extremely mindful of not eliciting too much testimony about the actual act. We did it initially before Your Honor even asked us to carve it back. Additionally, so there were details that were left out based on the court's instructions at the bench. They were additional details that were not brought out. But, Your Honor, this, stating that this is an entirely new story, is not accurate. And I'm certain that when they cross-examine Ms. Daniels, some of this will come out and some of this will come out on redirect. And I know that Your Honor has mentioned that you will allow me to elicit some of it on redirect in terms of what issues came up publicly and what details were remembered at different times based on different things. But they opened the door to the threat in 2011. And now Your Honor has asked us to discuss a limiting instruction on that, and we can certainly do that. We have written one that we have written up quickly that we can discuss with defense counsel, if they would like that. But Your Honor, this goes directly to her credibility, which they attacked. And while I'm sure will continue to attack, they opened the door in their opening, they opened the door in Keith Davidson's testimony, and these are not all new details. But at the end of the day, Your Honor, this is what defendant was trying to hide. And in terms of the payoff in 2016 before the election, this is an exhibit, if you would, of what they were trying, what Mr. Trump wanted to make sure didn't get disclosed. We have carved back details. We have been mindful of Your Honor's decision. And we have carved it back even before them. So I don't think there is any basis for a mistrial, Your Honor.
Thank you.
Just briefly, Your Honor, that misses the point a little bit of our argument. The point of the argument is that the reason why this evidence, in theory, is admissible over our objection is because these, in theory, are the facts which was presented to Mr. Davidson and Mr. Cohen so that they could evaluate whether they could enter into an NDA and, supposedly, the fact and the details that were going to be kept from the American people in 2016. That's the theory for this evidence coming in. The problem is that isn't what came in. And so what came in is this extraordinarily prejudicial testimony that has changed over time. and we can't fix that except to cross-examine her. But it has nothing to do with the case. The voters decided in 2016. The people are going to make a lot of that in their summation, I expect. And Judge, I don't think anybody can listen to what that witness said and think that that has anything to do with the charged conduct. And it's the kind of testimony that's so prejudicial that you run the very high risk of the jury not being able to focus on the evidence that actually does matter.
Your Honor, may I just add one thing? Mr. Blanche mentioned about the threat and so on. She testified about it directly that she was not threatened either physically or verbally by Mr. Trump. We made sure to elicit that. We made sure to say she did not say no. At the end of the day, it was the defendant who knew the details. We submit, Your Honor, he knew the details of what occurred in the room.
Okay, I can rule on this. All right. As a threshold matter, Mr. Blanche, I agree that there were some things that would probably have been better left unsaid. I think that there are some areas that would have been better if the people did not go into them. In fairness to the people, I think the witness was a little difficult to control, and that's why I was permitting some leading to give them the opportunity to try to control the witness. It was not easy. Having said that, I do think that there were guardrails in place. I do think that the court instructed the prosecution that there were certain details that we don't need to get into. And again, I'm not dismissing what you are saying. I do think that there were some things that were better left unsaid. Having said that, I don't believe we are at the point where a mistrial is warranted. There are a few things that go along with that. I will note that where there were objections, the objections for the most part were sustained. Where there was a motion to strike testimony, for the most part, that motion was granted as well. I will also note that I was surprised that there were not more objections at various times during the testimony. And in fact, at one point the court sua sponte objected, because there was no objection coming from the defense. So when you say that, you know, the bell has been rung. The defense has to take some responsibility for that. The court has done everything that I can possibly do to protect both sides and to ensure fairness, and that's why, again, I objected on my own. Whether these are new stories or not new stories, the remedy is on cross-examination. And in fact, if they are new stories, the more fodder that I will expect to see on cross-examination if you have any. I also believe, if you want, I will give a limiting instruction regarding the incident at the parking lot in 2011. Just bear with me one moment.
Your Honor, can I just object to that?
1 second, Ms. Netchels, please. Yes, Ms. Netchels?
Your Honor, I just want to be a little clearer. I did see that you, on your own, sustained it. But we had moved beforehand to try to limit all this, and Your Honor had ruled that it could come in, and I didn't want to keep saying objection.
That's a very general statement, Ms. Netchels. That's not accurate. If you are going to say something like that, be accurate.
Well, I'm trying to be accurate.
For example, I sustained a request that the people not be permitted to go into, or what was it, the Roger Ailes, is that his name, I agreed with you that that would be extremely prejudicial, and I didn't want them to go into that. So I didn't agree with everything that you requested, but I did agree with some things that you asked.
Right. And so, based on that ruling is what we were following. That's why we were not standing up and objecting. And once Your Honor signaled that you thought it had gone too far, we did start objecting very consistently. But up until that point, we really felt like Your Honor had ruled at the bench that they were allowed to do what they were doing. So I just wanted to be clear on that.
Well, we have to agree to disagree on that. I think that I said multiple times to you and to the prosecution that we were going into way too much details. We were going into much more than we needed to. It wasn't necessary. I still believe that it wasn't necessary. Having said that, though, I don't think that we have reached a point where a mistrial is in order. I believe that a limiting instruction as to that incident in 2011 will cure that issue, and I believe that you have a remedy of cross-examination. And as I said before, the more times the story has been changed, the more fodder for cross-examination that you have. So I'm going to deny your motion for a mistrial at this time. Anything else? Do you want to discuss a limiting instruction now?
Defense counsel confer.
Can we approach?
Sure.
At sidebar.
I'm sorry. I think we agreed on most of the language, and we can kick over the last part to you. So here I will read my version, our version, and then I will read their version. Our version is, You have heard testimony from Ms. Daniels regarding a 2011 incident in which she testified about being threatened in a parking lot. This testimony was permitted to explain any impact this interaction may have had on the witness's state of mind, her credibility, and her willingness to publicly disclose aspects of her encounter with Mr. Trump. That's the part we agree on. Our version then say, you must not draw any inference that Mr. Trump was behind any such threats, nor may you draw any inference unfavorable to the defendant as a result of this testimony. The version from the defense says, I instruct you that Mr. Trump had nothing to do with any threat to this witness, and you may not draw any inference unfavorable to the defendant as a result of this testimony.
Your Honor, can I just interrupt? I don't like even hearing it right now. This is going too quick. Honestly, we haven't really had time to think about it.
Do you want to think about it?
Yes, because even hearing it, it sounds like Your Honor is saying, yeah, this actually happened and we can test it. We're going to have to cross on this.
Okay, you can think about it and get it to me Thursday morning.
Yes, Judge.
Judge, may I have a few minutes to talk to the witness in an effort to just, perhaps, instruct her to be cautious about any testimony that...
Is there any objection to that?
No, Judge, no objection.
Okay, you can take a minute to do that.
Thank you.
Do you want to take a picture of this?
Yes, please.
Sidebar concluded.
Let me know when you are ready.
I'm ready.
As we discussed at the bench, the people submitted a proposed limiting instruction. Then I was also shown the additional language that the defense wanted to include. And upon further discussion, we have agreed that we are going to take some more time to think about it, and you will get it back to me by Thursday morning.
Yes, Your Honor.
Okay.
Thank you, Your Honor. Yes, Your Honor.
Okay. So, with the consent of defense counsel, Ms. Hoffinger has stepped out for a minute to give some instruction to her witness and make sure that the witness stays focused on the question and just gives the answer and does not provide any unnecessary narrative. Ms. Hoffinger, have you had a chance to speak to your witness?
Yes, Your Honor.
All right, thank you. Let's get the witness, please.